Right. Learning Unit 2, partnerships. Number 1 was a bit long, but we had to do an introduction. We had to talk about everything. So now we're going to speed it up a bit. So, partnership is an agreement between two or more people. If it's only one person, sole trader. And in this agreement, the partners agree to contribute towards a partnership for their joint benefit and for the objective of making a profit. So, with that definition in mind, you got to have 4 things. If you don't have all 4, you're not a partnership. Each partner has got to make an appreciable contribution. Remember what we said in Learning Unit 1? That means something that can actually grow or make money. Number 2, things must be done for the joint benefit of the partners. Everybody's got to benefit equally. There must be an objective to make profit. So that must be the idea. If they don't make profit, it just means they're unlucky or they're stupid. It doesn't mean it's not a partnership, but the idea should be that they should make profit. And number 4, they should be legitimate. So the 4 are, there must be an appreciable contribution by each partner. The business must be done for the joint benefit of all the partners. There must be the objective to make profit. You don't actually have to make profit. And it must be legitimate. So let's talk about the different types of partnership. The first, you get 2 main umbrella types of partnership. First is a universal partnership. A partnership in universum bonorum, a partnership for universal benefit. That's when the partners put all of their assets, all of their profits into the partnership for an undefined amount of time, usually forever. And the most common example is a marriage and community of property. So that's umbrella number 1. Umbrella number 2 is a particular partnership. Now, that is when partners have a particular relationship in which they are going to put particular assets in to do a particular thing with the idea that they are going to make particular profit. And anything outside of that does not count. So if you're going to have a partnership for a hairdressing business, any money that you make outside that is yours. It's not in that particular partnership. That is not the case with a universal partnership. Remember that. So it's for a defined purpose. Now, in that particular partnership, you have 2 little sub-umbrellas, parasols, if you will. The first is an ordinary partnership. Now, that is when the partners are jointly and severally liable for the debts of the partnership. Remember what we said in Learning Unit 1? Jointly and severally liable means they are funging everybody they can get. Run away first. Your furniture, all of your furniture will get carried out if you're the only one that they can get. If they can get a couple of partners, then they split the debt in between them. Okay, so you get ordinary partnerships. That's parasol number 1. Then you get extraordinary partnerships. Now, in an extraordinary partnership, the liability of partners is limited in some way. And you get 3 types. The first is an anonymous partnership. That means there are partners, yes, so 2 or more people, same as an ordinary partnership. But one of the partners is undisclosed, meaning that the general public does not know who they are. So if it's Mansa and Musa Plumbing Services, there might be another partner that we don't know about. That would be an anonymous partnership. The partner number 3, Mr. Jabulani, is not liable to the public if Mr. Mansa and Mr. Musa fuck up. He is only liable to them, Mr. Mansa and Mr. Musa, not to the public. Then there is a partnership en commandita. En commandita means it's got to do with assets. So an undisclosed partner, like an anonymous partnership, gives assets to the partnership and is not liable beyond the point of those assets. So the oak, for example, will give the building, but will not be liable for anything else. So a partnership en commandite is could be seen as a type of an anonymous partnership. So the two so far: anonymous partnership, the oak not known, not liable to any third parties, but liable to the partners. En commandite, the oak gives a particular asset and is not liable for anything else other than that asset. Then you get a special partnership. You don't do that anymore. That was under acts that have now been repealed. When you have general partners, remember, those are the oaks that get funged no matter what happens. And you have special partners, which means that they're either anonymous or en commandite. Okay, so just to recap that little section, partnerships, we have two main umbrellas. Universal, a partnership universum bonorum means that the partners give everything they've got for the benefit of the partnership for an unspecified amount of time. Everything counts. All profit, all assets count. Most common example, marriage and community of property. Particular partnership is umbrella number 2. Particular assets towards a particular thing with the guys that are making particular profit from that particular thing. And underneath that, we've got our two parasols. Ordinary partnerships, you fung them regardless of what happens. Everybody's on the chopping block. Then you get extraordinary partnerships. We limit the liability of the partners in some way. Anonymous partnership, Lekker, one partner is undisclosed and is not liable to any of the public, but liable to the third parties. Not liable to any of the third parties, but is liable to the other partners, excuse me. Partnership en commandite, the oak is only liable for the asset that he gave and for nothing else. Then you get a special partnership, which is now no longer allowed. It was under acts that have now been repealed, where you can have general partners, the oaks that you fung, and a special partner. Okay, let's talk about the aggregate theory of partnership. So South Africa listens to the aggregate theory of partnership. That is the idea of partnership that we follow. What that means is that we, as under South African law, do not see partnership as a separate legal entity from the partners. It is basically seen as a contract. And when we do business trusts, we're going to, in a little bit, we are going to have to discuss in greater detail why it is that we have a situation where business trusts have to be engineered in such a way. If they are not, they're automatically seen as partnerships. So, because we do not see partners as partnerships as legal personalities, any rights that the partnership has are the individual rights and responsibilities of the individual partners. Any assets are not owned by the partnership as the partnership, but are co-owned by the individual partners. So, for example, you could have a case where a warehouse is owned by Mansa Musa Trading CC, so it's owned by the company, but in a partnership, that's not the case. The Oaks names on the title deed will be Mr. Mansa and Mr. Musa. They are seen as co-owners. And remember, partnerships do not have perpetual succession. What that means is if there is a change in the makeup or number of partners, not a chance. We have to start again. So there's a couple of ways that a partnership can be dissolved. It can be dissolved by mutual agreement, by court order, the expulsion of time, which basically, well, you can use a simpler word. The word they give is expulsion, but the passing of time. So if Mr. Mansa and Mr. Musa have not done business together in 20 years, it is assumed under the law that the partnership no longer exists. Yeah, so that is what we are dealing with at the moment. Sorry, let me just decline that call. Okay, so we've established the fact that they do not have separate legal personality. However, South African law is nothing if it is not full of exceptions. In two cases, insolvency and litigation, we have two exceptions. First, if the partnership goes insolvent, they go after assets that have been used by the partnership or that are co-owned by the partnership before they go after individual members' assets. That sounds a bit complicated, but let me explain. So, for example, let's say we've got Mr. Mansa and Mr. Musa, and they are doctors, and they have a doctor's office. And let's say, hypothetically speaking, Mr. Mansa and the doctor's firm of Mansa and Musa goes bankrupt. The creditors will go after the building in which they had their doctor's office and the car that they used for their partnership before they go after Mr. Mansa's house, Mr. Musa's house, and their own private cars. So the first one, as we said, insolvency. The second one is litigation. That's the fun bit. So a partnership, although it does not have separate legal personality in most things, it can sue and be sued in its own name. So the doctor's firm of Mansa and Musa can sue in court. It's recognized in court as having the ability to sue. Mr. Mansa and Mr. Musa don't have to sue in their individual capacity. So no separate legal personality unless we're going bankrupt, unless we're going to court. And even if we're going bankrupt, yes, the Oaks are jointly and severably liable, but they will go after what they can that was used by the partnership before they go after the individual partners. But if they go after the individual partners, they're coming after you for everything. Right. Now here come the lists. First thing, what are the rights of the partnership members? There are 5. So let's do them one by one. The first one is they have the right to share in the profits of the partnership. It's not like a company where they go, this Oak owns 10%, he gets 10% of the profit. This Oak owns 5%, he gets 5% of the profit. Unless specified by a partnership agreement, any and all profits are divided equally among the partners. If there are 2 partners, we split it twice. If there are 5 partners, we split it 5 ways. Share in the profits of the partnership. Number 2, they have the right to participate in the management of the business. Remember, for a company, that's not the case. For a shareholder, necessarily. For a partnership, if you're a partner, you have the right to run the show. Obviously in consultation with the other partners, because you don't want to be a duas. But you have the right. Number 3, you have the right to compensation. So you have the right to get paid for your work if you are a partner in the business. So we have a right to the share in the profits. We have the right to participate in the management of the business, with the right to compensation if we're doing work or if compensation is called for. We have the right to look at the books. So any partner has the right to look at books. That is a right that is an inalienable right. You cannot take that away from a partner, even if he is a silent partner or an anonymous partner. He can look at the accounting. Number 5, he has the right to a share of assets on dissolution. So let's say, for example, the partnership dissolves and the property is worth 20 million rand and there are 5 partners. Each partner then is entitled, by and large, to 4 million rand. So when the partnership dissolves, any assets, they value them up, Nedbank values them up, and then splits it however many ways. So, sharing the profits, participate in the management of the business, compensation, inspect the books, share of the assets upon dissolution. So, they've got lots of rights, but they have even more duties. Here's 8 duties. 5 rights, 8 duties. Number 1, they've got to contribute towards the partnership. Remember, we said they've got to make an appreciable contribution to the partnership. Assets that will make money, or money that can be used to make more money. Number 2, they have to share in the losses. Yes, they will go after, that is finished, they will go after the partnerships stuff first. But technically speaking, and I don't want there to be any confusion, technically speaking, because everybody is a joint owner of the partnership's assets, every partner has the duty to share in loss. So if the debts are, let's say, for example, 1 million rand, and there are 5 partners, they must now share those debts equally. Then each person should technically be liable for 200,000. If they can only fund the one guy, then that one guy is responsible for the 1 million rand. So those are the first 2. Contribute towards the partnership to share in losses. Number 3. By the way, before we get to number 3, as I said, I don't want there to be any confusion. You are jointly and severally liable regardless of what assets they're coming after. So they will take your assets, but you are seen as owning the partnership assets in your own right and your own personal assets in your own right. So they will fund you for something. So yes, they'll go after the partnership stuff first, but they will fund you for something. Number 3, exercise care and skill. So don't be an idiot. Run the business properly. Don't run it into the ground. Number 4, fully disclose any relevant information. If you see something, say something. If you see that a competitor is opening up down the road, or if you hear that your uncle is going to open up a shop a K away that does exactly the same thing, say something. So contribute towards the partnership, share in losses, exercise care and skill, fully disclose any relevant information. Number 5, account to the partnership. Simply put, tell the Mensa what you are doing. If you have done this, this, and this, A, B, and C on behalf of the partnership, tell them that you did that. You have to tell them. There's a duty of accountability. So if you have done something good, you take responsibility for it. If you've done something bad, you take responsibility for it. And you tell them that you've done it. Either way. So contribute, share in losses, exercise care and skill, disclose information, tell the people what you've done. So account to the partnership. Number 6, act in accordance with the partnership agreement. If the partnership agreement says you must do this, for example, you work on Monday, Tuesday, Thursday, Friday, Sunday, then do that. If that is what has been agreed and provided is legal, do that. Don't disobey the partnership agreement, because then the partnership, obviously, we run into problems, becomes void. Also, number 7, acquire benefits for the partnership. Sook the money. Go after business opportunities. If you are now standing at Pick and Pay and you have a partnership that is a doctor, that is a partnership of doctors, and this woman is there saying she wants a facelift, tell them, you doctors, you do facelifts, can she be your client? So acquire benefits for the partnership like that. Go after clients. Go after good opportunities. And last but not least, guard against a conflict of interest. Don't put yourself in a situation where you have a conflict of interest. Now, what is a conflict of interest, you asked? That in itself is very important. Conflict of interest is when you are caught in the middle. So if the partnership wants to buy a building and are presented 5 buildings by 5 different estate agents, but the one estate agent is your cousin, then that is a conflict of interest, because obviously you're going to want to go with your cousin. I don't personally see a problem with that as long as it's a good building. But yeah, that is seen as a conflict of interest, because then you would be seen as favoring your cousin over getting a good building. So yeah, the 8 are: contribute towards the partnership, to share in the losses, exercise care and skill, fully disclose any relevant information, account to the partnership. That's 5. Number 6, act in accordance with the partnership agreement, acquire benefits of the partnership, get clients for the partnership, for God's sake. And number 8, guard against conflict of interest. Right, now, so we got our benefits, we got our duties. Now there are 8 ways in which a partnership can be dissolved. The first is effluxion of time. If the Mensa have not done business together for 20 years, it is seen that the partnership, thank you very much, is gone. Doesn't exist anymore. If they have a particular partnership, we are going to be in partnership from 2021 to the end of 2022. And the end of 2022 comes. Partnership finished. Or they say, we are going to be partners till we build this. We're going to be partners for the time we build this building. And the building's built, partnership's done. So effluxion of time, number 1, ending of the undertaking or objective, number 2. So if you have a goal and you've reached the goal, partnership is finished. Number 3, mutual termination. If the partners decide, thank you very much, we've had enough, done, then partnership is finished. Number 4, change in membership. If one oak leaves, finished. If a new oak comes in, finished. You got to make a new partnership agreement. There's no perpetual succession. So the first 4 are effluxion of time, ending of the undertaking or objective, mutual termination, change in membership. Number 5 is insolvency of the partnership or any of its members. If one of the members is going bankrupt, thank you very much, we're out of here. Done. Number 6, notice of dissolution by one of the partners. If the one oak says, Yara Mensa, I'm leaving. Done. Then, finished. It's the partnership is done, which is the same as mutual termination in a sense. But mutual termination is where they all agree to end it. Notice of dissolution is when one oak says he's leaving. If one oak says he's leaving, finished, done. So the first 6 are effluxion of time, ending of the undertaking or objective, mutual termination, change in membership, insolvency of the partnership or any of its members, notice of dissolution by one of the partners. Number 7 is a court order. So courts can break it up. And number 8 is if the partners are enemies during a state of war, but that's the most rare one. Okay. What is the difference between a principal and an agent? So a principal acts on their own behalf in exercising a contract. An agent acts on behalf of others. So a partner, when they exercise when they sign a contract on behalf of the partnership, they are acting as both a principal and an agent, because they are acting on behalf of themselves and the other partners. So that is because partners have actual authority, meaning they have been given authority, it's been written down. That could have been given by partnership agreement, or another way it could be done by court order, or they could have ostensible authority. Even if they have not been given the authority, it appears to the outside world as if they have been given that authority. So obviously circumstances alter cases, but if it looks like he's been given the authority, then the third parties can go to court and say, no, we thought he had authority. Any reasonable person would have thought he had the authority. Fang him. Perfect example of ostensible authority. If the other partners knew what he was doing, didn't stop him, then that is ostensible authority, because although they didn't specifically give it to him, which would make it actual authority, they didn't stop him. So they can't come later and go, sorry, we didn't know about this. We had no idea. So they are estopped. It's a nice legal term, that. They are estopped from denying such. And that is learning unit 2. So remember, we have 5 duties, 5 rights rather, 8 duties, and 8 ways to end the place.